Maybe I read this one when it came in. When did it come in?
It was a final.
Yeah. All right. Yeah, I might have read it then. Let me look at it real quick. Yeah, settle in. Okay, yeah, I read this one. Okay, so go ahead and hit your high points.
Did you mind me?
Yeah, you first. Your motion.
Thank you so much, Aaron. So, as indicated, we're gonna rely on the motion that we found, but just the high points are this. The defendant was stopped by a third party. And so what happened is, they did do a PBT and it came out with triple zeros. They did a nystagmus test, and there was no nystagmus. They did the walk and turn test and she did pass that. The tests that they administered, I think, were more geared toward alcohol intoxication, not really whether she's under the influence of drugs. There's other tests that they can use, convergence, and other tests, they didn't use those tests. So basically, we got to look at this case as the officers looked at it at the time of the arrest. So we don't have the benefit of having the result of the blood test.
Yeah, they're on the street at this point.
So there's some, I think, important conversation between the officer and the witness who originally stopped Mr. Parker. And so what the officer had told the witness was that they were still trying to figure out if the defendant had a medical issue. And then there was several conversations that went back and forth as to this issue. And the officer indicated to the witness, and that's sort of the state of mind, that they were still trying to figure out whether she had a medical issue, Your Honor. And the other thing is, sort of the point of my motion is, when you submit a affidavit for search warrant, you can't just leave certain things out. There's the fragmentation. And so one of the big points they were making is that my client indicated that it was Saturday when it was Monday, but they forgot to indicate that they asked her how many quarters in a dollar. She said 4. Nothing's indicated in the affidavit to that extent. They also asked her who was the president. She said Biden. So, so I think the affidavit is slightly slanted when they don't give all the information to the magistrate. So I think this is kind of an unusual case because you generally don't have a party
involved
stopping someone, on a misdemeanor case,
Did you attach the affidavit to your?
There's attached.
It's on your response. I thought I had seen one. All right, keep going.
I just think that based on the officers, it didn't seem like they knew what was going on, and the tape that I saw, the paramedic indicated to the officer that my client was answering questions appropriately. Now, to be fair here, some of the portions of the tape were redacted and we couldn't understand some of the conversation, but the information that we got that we could, and it's footnoted in my motion.
Right.
So I think based on all that, it's not a alcohol case, it's a drug case, and they really weren't sure what was going on, and she's hypoglycemic, and they had that information as well. They did check her sugar, and the paramedics did say they thought her sugar was fine at heaven. So that's the high point. So,
Yeah. So your argument is they had no reason to believe there was a crime being committed. Send her on her way.
well, I think really what happened is, in the pragmatic view, they wanted her to, go to the hospital. And I think if she went to the hospital, I'm just guessing, I'm just being straightforward here, Your Honor. I think that would have been maybe the end of it, I don't know. But, for whatever reason, she didn't, want to go to the hospital. So I think that's why things escalated to the point where they were.
Okay, response.
This third party assisted police by having Mr. Parker board because according to him, the suspect vehicle drove into oncoming traffic, drove off the road, almost crashed at Chaps gas station, had been driving on the shoulder out of the on-ramps upon his way to 275. Probable cause is determined based on the totality of circumstances. Here we had, well, the defendant claimed that the only information that police relied on were the fact that the defendant was on 700 feet or sexual charges. However, defendant deeply discounts, if not admits entirely, her own admission to consuming controlled substances that evening. Specifically, when she told the paramedics that she took Xanax, which is a muscle relaxer. Defendant has slurred speech, trouble with dexterity, trouble maintaining balance, was driving in reverse without realizing it, had a delayed response time, got the day of the week and the year wrong. Defendant had trouble getting in and staying in the starting position, used her arm to balance, took the incorrect number of steps, failed to walk and turn. Eventually, the officer had to stop the field sobrieties in fear of her safety because she was falling over. Defendant argues that the arrest was based on a guess between two plausible explanations, implying that her behavior was because of some sort of medical emergency, which is precisely why police called medics to the scene. However, once the medics, again, the defendant is fine. Okay, I'm not going to be able to check her. She didn't realize it was normal, but she did disclose that she was hypoglycemic, so they wanted to ensure that that was okay.
Right.
She did disclose that she took a muscle relaxer that evening, and even the medic said that most people who take muscle relaxers should not operate a vehicle. It is clear here that based on all of that, there was more than a probable cause to suspect that the defendant had been operating while intoxicated. But frankly, the officers believed that she was intoxicated or impaired before they called medics, while they called medics, and after they called medics, which is precisely why, when she was cleared, they arrested her under suspicion of overdose. I realized then that the defendant argues that the search warrant provides no information to support that there was presence of drugs in the defendant. However, again, the defendant fails to mention on the form itself, the officer very clearly identified that the defendant was arrested for operating under the influence of drugs, that the PDT administered was 0.00, that he goes into the walk and turn, the one leg stand, believed that they were under the influence based upon his personal observations. Defendant seems to believe that because the omission of stating that medics were on the scene is somehow indicative of being defective. However, it didn't matter. She was cleared. So it had nothing to do with the medical emergency and all to do about what she had consumed, which is precisely why they sought a search warrant. He also fails to mention what it might have been, well, I believe it was in the police report, but she also admitted to taking, in addition to the muscle relaxer, Xanax and Nyquil. Even if this court determines that the search warrant for blood was somehow defective, there is the good faith exception rule here. The officer relied on that search warrant to obtain the blood, got the blood, and it was found out to believe, well, to be clear, that the suspect or defendant had more than 8 times the therapeutic drug range of the Xanax. So the suspicions were confirmed with the blood test.
Mr. Bohannes?
Yeah, just briefly. Sure. Your Honor, first of all, to put it in clear context, she indicated that she took her medication at midnight. She was stopped at 12 noon the next day. So I just don't, I want to make sure.
Right, I got the content, got the hourly, yeah.
So, and there's, if she wants to rely on, now, going to this, medical report, which is afterwards, it's 4 times, it's not 8 times the therapeutic limit. The therapeutic limit is up to 100, milliliters per,
Okay,
and so, but, as I said, the officer, why would the officer indicate to the witness, witness that they're still investigating, they think it's a medical issue, and then say anything with regard to, she's, they think she's under the influence of drugs. And right after he told her that he thought it, was a medical issue, they arrested him. Right after that. So I do think, when you take into consideration that the tests that were given are not for alcohol intoxication, not drug, under the influence of drugs. And that when the best thing that shows the officer's state of mind is his own statements to this other witness, because there's, that's telling you what he's thinking. And when he said clearly on the tape was that we don't know. We're still investigating a medical issue. And then within less than a minute, she's arrested. There's nothing else substantial. And if you want to go to the drug test, there's nothing other than the Xanax, the Pramlethrin in her system. And it's, where is that?
Yeah, there's a couple of results. That was the quantified. There was also detected doxylamine, dexto, trimethylforin, and lexomethylforin.
oh yeah, that.
It's detected, but I
Right.
don't even know what that is.
Okay. All right, anything else?
No.
Just briefly, according to the revised critical care 2020 therapeutic dosage range, alprazolam was actually therapeutic dosage range of 5 nanograms to 50 nanograms, and the milliliter is determined to have 415 nanograms per milliliter. And the defendant is inaccurate when saying that the officers believe she was having a medical emergency. Again, at the time of the stop or the time of the connection, during the medical evaluation and after the medical evaluation, they believe that she was impaired at the time of her operation of the vehicle, which is why they arrested her based on that and saw a search warrant.
Okay, thank you. I remember any time I get one of these, when they're talking about the search warrant, of course, I put myself in the place of the magistrate to sign the search warrant. So first of all, let's avoid the suspense. I'm going to deny your motion. Now let me explain why. So first of all, I think it's pretty solid just on all the driving issues. I think that's pretty solid. Then you add on to that the medical team that had checked the lady out and says, we can't find anything wrong with her. Her blood sugar is good. That gives weight. But when you throw in the fact that she admitted consuming controlled substances, I equate it to this. Have you been drinking tonight, sir? Oh, I had 2 beers. Okay. They always lie about how many beers they have. So if she says I had muscle relaxants 12 hours ago, it's like the guy that says he had 2 beers. She's admitted she put something in her body. So let's look into it further. The fact that the officer told something to a civilian witness, I mean, maybe the officer didn't want to get into too much of the business with the civilian witness. I don't know. But I think just what the officer had, the medical team said there was no medical issue they could find. The lady admits she's been consuming controlled substances at some point in the recent past. They've got seriously erratic driving, and I think that's putting it mildly. I think it's plenty of probable cause for them to arrest and then find out what's in her system. So motion's denied. Can we pre-try it today? Do we not have anything else going on? Okay, so I'll kick you back out in to do what you do. You're welcome so much. Miss Medina, you got anything ready? Then get out there and get something ready. And I've got a plea agreement in front of me.
Yeah.
All right. Ms. Parker, you've discussed your rights and options with your counsel? You understand those rights and the options they give you? You understand the possible penalty for the charge, the new charge? Understanding all of that, are you pleading guilty freely and voluntarily to impaired driving?
No contest.
No contest. Okay. All right. Well, you understand when you say no contest, you're literally saying, Judge, I'm not fighting that charge. If I can find a factual basis to accept the plea, and obviously I've heard enough facts in this case, I think I can, then I'm going to move forward. We're going to schedule you for a probation appointment. You'll eventually, the three of us will be back for sentencing. You understand that's where we go with this. So understanding how the no contest works, understanding the possible penalty and your rights and options. Are you pleading no contest today freely and voluntarily? All right. Counsel, would you agree with me that the facts that we've discussed already? Thank you. Then I will accept a no contest plea to the added charge. I will dismiss the original charge. And I'm going to send you downstairs to make a date with our probation department. They're going to have you come back. They'll interview you. Based on that interview, they'll put together a report, a sentencing recommendation. We'll all have a chance to look at it. Then we'll talk about whatever you need to talk about before I sentence. Understand all that? All right. And you've already got a bond. We'll continue that bond.
Thank you so much.
You're welcome.
You guys have a great day.
You as well. Is this Mr. Boone? All right. Good morning, Mr. Boone. Counsel, your appearance for Mr. Boone?
Yeah, what's on behalf of Mr. Boone here?
Got it. Okay. Tell me about it.
To allow me no license.
All right. Mr. Boone, did you discuss your rights with Mr. Batar?
Yes.
You understand those rights and the options they present to you? You understand the possible penalty for the added charge? And understanding all of that, are you pleading guilty freely and voluntarily to the added charge today? Did you drive a vehicle in Sumter Township on July 13, 2024 while your license was suspended, revoked, or denied? I'll accept your plea to the added charge if Mr. Batar is satisfied with the factual basis. All right, I'll dismiss the civil infraction as well. Why don't you tell me about Mr. Boone so I can decide what sentence should be?
He had a license up until a few months ago. He's going to work on getting it back again. Outstanding works. We understand the statement of responsibility.
All right, so what's standing between you and driving legally? Money that you got to pay other courts? That's all it is a money thing? Okay. Are you working? When's the last time you worked and where were you working?
Like about a month and a half ago at Austin Bank.
Okay, and how long were you there? All right. Anything you want me to consider before I sentence you? All right, so you owe us money on other tickets. Do you owe other courts too? Or is it just us that's stopping you from getting your license?
I believe it's just.
Okay, because what I see is an impeding traffic and no proof of insurance ticket. And then we've got a Sumter registration or plate charge. That's part of this one.
Yes.
Okay, all right. Then you're not working, so you got no income coming in. Do you have reliable transportation? I mean, you got a relative that can get you around if you need to go someplace?
Only if it's like close.
Yeah. You're in Ipsy, so is this area close enough?
Well, yeah.
Okay. So here's what I'm willing to do for you. I'm willing to give you my standard $500 fines and costs and waive that if you get your license reinstated within a reasonable amount of time. And then I'm willing to give you a way that you can pay this $804 off without cash money. So we've got a program here we call our community enrichment program. If you hook up with Mr. Taylor, who runs that program, and he tells you on these dates and times, you got to show up at these locations and do labor, we'll credit you towards your fines and costs and get this closed off. This $800 that you owe on these other ones, we'll get those closed out. I think from what you're telling me, then you can go get your license back, come show me your license, and that'll close today's file. Is that a workable plan for you? Now you can always just pay the $804. You know, if you got a grandmother that wants to hand you money or something like that.
Now this is where things get interesting. Instead of just punishing the defendant, the judge is actually offering a path forward. This is a classic example of judicial discretion, where the court balances accountability with opportunity. But here's the real question. Will the defendant actually follow through? Or is this a setup for an even bigger consequence later?
But I'm giving you a way to take care of the whole thing with no green.
When that would add up the cost of the 800 and the 500, or just have to pay 500.
No, literally what I'm going to do is say on this file, today's file, you owe $500, but I'm going to pay you $500 to show me your license. Right? So if you don't do it, for example, if I give you 30 days to do this, we'll talk about whether or not that's enough time. If I give you 30 days to do this and you don't do it, then you owe me this 500 plus the other 804. You follow me? So I'm putting a big monkey on your back. You got, if you commit to it, you got to get it done or it's going to really cost you. Making sense? All right. Now, is 30 days enough time to do that? If you don't think it is, I'll give you 60. But whatever you commit to, there's no more time. You follow me? So if you come to me in 45 days and say, I don't think I'm going to get it done in 2 weeks. I need some more time. I'm going to say, no. All right. So 60 is enough. I'll tell you what. I'm going to give you 60. If after you talk to Mr. Taylor, he says he can't find enough work for you within 60 days, then we'll look at it again. I don't think he's going to have a problem.
Yes, work on the 804 and try and get your license, correct, Judge?
Yeah. Brother, this is a really good deal. Seriously. Do you know anybody else that the court paid them $500 to get their license? Yeah.
Thank you, Judge.
Where'd you go to high school? You graduate? When? What was your GPA? You survived COVID in school.
Yeah, it cut my last year short, but my GPA was maybe either 3.1 or it was between 2.1.
Okay. All right. So what are your plans? Okay, good. We need a lot of that lately. Yeah.
So Judge, it's 500
Today's file is 500 or a valid ops
within 60.
within 60. And on the 804, I just sent it down to community enrichment. I don't think Mr. Taylor is in the building today. All right. So go downstairs and check and see if he's here. Come on up. Once again, monkey's on your back. If he's not down there to talk to him today, you got to get in touch with him quick because you only got 60 days to make this plan work. Got it? Good luck. Good morning, sir.
Boy,
How are you?
tired.
You must be working.
No, my daughter keeps me up.
Oh, boy.
One thing on this day, slugs are whipping and drives me crazy.
Yeah. Yeah. All right. So let me see what we got here. You're okay. Okay. All right. Yeah, I got it. Go ahead.
Ms. Heller has daughter, there were 40 incidents of required. I would have no objection to waiving the finding.
I'm ahead of you.
So I don't need child locks on phones, password locks, and apps that restrict usage.
Yeah. Yeah. Yeah.
I hope that this will resolve.
Yeah. Are you technologically savvy enough to figure that out? Okay. All right. So, you understand your rights and options? You understand the possible penalty for this misdemeanor? Understanding all that, are you pleading guilty freely and voluntarily? Or is what she just told me all true? Okay. I'll accept your plea. I'm going to put you on a delayed sentence for 12 months. What that means is do everything I tell you to do and no new charges. At the end of 12 months, we dismiss this. What I'm going to tell you to do is stop it. Make this stop. Okay. I'm not going to charge any money. Just make it stop. Now, if you run into technological problems, so you
I'm
just,
just later after take that one out of the phone and she
She'll drive me bad if she doesn't get a follower, so they would.
Right.
I'm afraid it'll be a tall.
Yeah. So just here, if you have trouble, because right now you think you can do it. What you're saying is you're gonna make it stop. Right now you think you have a plan. If that plan blows up, don't just not come back. Come back and see us. So we can talk about where we can go from there. Because you just gotta stop. I mean, people, you know, I don't have to lecture you, you know. Okay, all right, got it? Good luck. All right, and Mr. Bridges, you understand the possible penalty, including 2 points?
Yes.
And you've discussed your rights and options? You understand all those? Understanding all of that, are you pleading guilty to the charge? Are you doing so freely and voluntarily today? Did you drive a vehicle on, what is that, March 9, 2024 in Huron Township? At that time, was your license suspended, revoked, or denied? I'll accept your plea if Mr. Bitar is satisfied. All right, what should I know about Mr. Bridges before I sentence?
Someone have me here in Romulus, here, single, no children. He's employed full-time, works 2 jobs, works at the airport cleaning and does security at a Ford plant in Brownstown.
Good.
He just doesn't have a valid license, but he has to drive.
Have you ever had a license? Got to get one.
So I explained it, when we get out of here today, he needs to go to Secretary of State and start working on
Yeah.
that process. And work is important. We know public transportation isn't that great.
I'm glad to hear you're working. Yeah. Here's the problem though. You can't afford not to have a license. Before today, you owed me $888. You can't, I mean, I don't know how good your jobs are, but they're not that good. Right? Do you have any idea what it's going to take you to get your license? That doesn't tell me anything.
Outstanding tickets, Judge, all of them. Well, I shouldn't say all of them. There are outstanding tickets.
Well, where else besides us? What other courts you got to deal with? Just Dearborn and us, that's it? So just 2 courts, Dearborn and 34th. Okay. All right. Are you in a position to get set up on a payment plan on the $888 you currently owe us? You can do some monthly payments? How much can you do and when can you start? How much? How much next month?
How about 250 months, Judge?
That's fine. All right, so what I'm going to do on today's file, you owe $600. I'm going to give you 90 days to pay that $600 or bring me a valid driver's license. That gives you enough time to pay these off at $250 a month. You got to get Dearborn paid off and you got to get your license. If you, Taylor, he said he just paid Taylor. So, but yeah. So as long as you can get Dearborn out of the way, do what Secretary of State needs to get your license. If all that happens within 90 days, I'm literally going to pay you $600 to get your license. That's all you're going to say? Thank you. Merry Christmas. Happy birthday. Understand what you got to do. Go downstairs and set up that payment plan. I wrote the notes, but you got to walk out of here with a payment schedule for that $250 a month. All right. Good luck. Thank you. You too. Helmer. How are we doing? Excellent. So let's see. When did I see you last?
December 13th.
So tell me what's been going on in your life.
So I got out, I left a manual house, recovery house, May 1st. I apologize for not coming.
You finished the program though. Yeah.
I have paperwork that I could email Emily.
Okay.
I would have stayed longer, but they were getting evicted because they lost grants from the VA.
Okay.
Now I'm living in Lincoln Park with my father. He's retired, why not come?
What's your sobriety plan?
My clean date, 2nd, 2023. I'm going today.
Okay. So what are you doing to stay that way? I mean,
I got 2 weeks, every 2 weeks I go to an NA meeting, it's called Recovery of Rock. I'm looking for a new sponsor because.
Okay.
my Sponsor was attached to a manual housing.
Oh.
When everyone left there, so
right. Yep.
in the process of getting the license back, I paid mine not off, my probation fees, I don't know.
Is that all it is money?
No, I had it involved.
Okay.
I had this,
Waiting the results?
yeah.
Yeah. Did you have an attorney with you?
No, I didn't have 4,000 versus pay for an attorney. Yeah.
Yeah. Here's the problem. Did you talk to more than one attorney? All right.
All at least 4,000.
Yeah. So the problem is, and thanks be to God, as my grandmother said, I never went through it personally, but I've talked to a lot of people in your shoes. And what I've heard, what I've seen is if you've got an attorney that specializes in that, or at least does a lot of it, they know exactly how to get you set up so that when you go in for your first hearing, you get something, right? Because they know the things that the hearing officer is going to want. So they'll tell you in advance, get this done, get this done, get this done before you even go in to see the hearing officer, right? So when you leave the hearing officer, you've accomplished something. Probably, is this your first hearing, the one you went to last week? Yeah. So I'm going to guess, and I'm not trying to jinx you, but I'm going to guess all you're going to hear from them is, here's a list of things we want you to accomplish before we see you again. Okay.
Well, I did do the restoration packet.
Okay. Good.
Paperwork from.
Yeah. Yeah. Yeah.
There's
Well,
no reason why they,
good luck. Good luck.
no reason why they shouldn't be restricted, but I just don't have a good feeling.
I've had more than one attorney tell me that a lot of it isn't whether or not they can check enough boxes. It's how bad do you want it? So my cynical mind, well, you've paid an attorney, you want it bad enough to come up with that money. And if you don't do that, then they might want to have you jump through some extra hoops just to make sure you want it bad enough.
My attorney that's out
Yeah.
there. What is he, man? He basically told me, he goes, you can pay me this money, but I can't even guarantee you that.
Yeah,
this-
yeah. No, there's no guarantee.
It's up to you.
Yeah, there's no guarantee. Yeah. So are you working now?
Working with others.
Okay. Okay. Yeah. It's, so is it full time?
It's no, it's between 30 and 40 hours a week.
Okay. All right.
I live with him, so it's
It's
just,
easy. Transportation isn't an issue.
I would have had him come up and sit with me, but he's, can't walk that good.
No. That's, I trust what you're telling me. Okay.
Joe, we're present, present.
That's the security one. Thank you. That means a donut showed up.
Oh, no, she would have known, she would have understood that, trust me.
All right. You got any other court cases going on?
No,
Okay.
I want to take care of it. Last one. Can you ask me what I know?
Yeah, give me a minute. Let me find the right piece of paper. Yeah, usually when you're represented, you don't sign anything. Yeah, you pled guilty to the larceny charge. 12 months, non-reporting probation, no fines or costs. Told you to work the program at Emmanuel House.
I seem to think that we got it dropped to a disorderly accident. That doesn't make sense.
I don't think it was. That's not what the ROA shows.
I mean, I don't know this one. What's the case number?
21-0850.
So, and after the detective question, the evidence of the case, and I didn't get a response from him. I was gonna fight the case, but my attorney was at the police and out today.
Is there a plea on the bottom? It would have been in person because it was on there.
Yeah, I'm just looking at the ROA.
Yeah, the ROE doesn't state anything,
Yeah.
but there's plea agreement,
There's nothing on the blue sheet. Usually I stamp it with the reduced plea.
right?
Yeah, so my notes that I make on the blue sheet, that doesn't mean anything to you, but there's one place I make notes by hand, and then there's another note where it gets typed in when she's doing it. Both reflect that it was no reduced plea. All right, good luck to you. Just send it down to Emily, I guess. No, you're good. You're good.
So,
Mr. Mays, you got something? Name?
Osborne, oh yeah,
I don't have any paperwork from the prosecutor yet. Do I need any? Or is it you?
well,
We're just going to adjourn. It's nice to me that the department's gonna reissue us a second. I just want to ensure that they're going to do that before I just.
Okay.
Willie Mays, on behalf of Ms. Osborne, Judge, we're opposing the adjournment. The prosecutor says she wants to dismiss. We don't adjourn to maybe dismiss. And Ms. Osborne, her position, so I gotta take another day off from work and I gotta come back.
Yeah.
Just see if the prosecutor's dismissing.
Right.
It's not fair to,
Well, I can do this. Let's assume they're not going to dismiss. What are you going to do with the file?
I had asked for discovery. She indicates that she has provided discovery.
Okay.
I was seeing the report.
Okay. Okay, so we can't set it for trial yet. I'm fine. I'm just trying to avoid
I know.
the wasted effort back, because if we have a date on this file, we have a date on the calendar, and if it's not dismissed, then we proceed on this one.
I appreciate where she's coming from. She wants to make sure that the state fixes it.
Yeah.
Can't.
Yeah.
And technically,
She shouldn't have to wait to figure this out.
they can't issue the same charge and the same offense at the same time that the current case is active.
They do it all the time.
I know, but it's not,
Yeah.
So prosecutor should just move to the.
I still need to rounds.
Okay. Let's, go to October, maybe? Well, no, I don't want to suggest that because we can make it speed trial.
You'll be going to a different judge, so
Oh.
it's, I mean,
I don't want to do that because this is, then the history gets lost.
Yeah.
It really shouldn't take long. I mean.
Okay.
the October date that I do have.
I don't want to do that.
Hold on, we just gave you an August 22nd. Okay? So here's what's going to happen. By then, you'll either notify us, we'll dismiss it, and you won't have to deal with this one on the 22nd. Yeah. Well, hell, we can put her on Zoom that day. Because we're not, what are we going to do on the 22nd?
I know. Right.
You're going to find out before the 22nd that this case is going forward. You're going to make a motion for discovery. She doesn't have to be here for that.
Right.
So we can have her on Zoom. If it's not dismissed before the 22nd, she can appear on Zoom.
Thank you.
All right?
Appreciate it.
So I'm just going to adjourn this pretrial until the 22nd. Okay, all right, we're on, we got a plan. She's confused as hell, so explain it. Explain it. I can see her.
Thank you for the option, sir.
You're welcome. I can see your face. You're trying to figure out what happened right now. Mr. Carter, come on up.
Hey, this morning, Your Honor.
Wonderful. Counsel?
Crystal Medina, Your Honor, on behalf of Mr. Carter, with regard to the arraignment, we would wait for more reading as sir, would you please state your opinion for the record? Your Honor, I think of the opportunity of prosecutor, it was actually the prosecutor, although this is a criminal case, I did speak to the subject prosecutor, Ms. Woody Carter has recused herself with regards to this matter. The pre-trial at this time, he is prepared to plead guilty to driving while license suspended, revoked or denied. In exchange, a civil infraction will be dismissed. I have a transcript of the point that will be added to.
Okay. Okay. All right, Mr. Carter, you've gone over your rights and options. You understand all those? And you understand the possible penalty for the charge. Understanding all that, are you pleading guilty to the charge of drove while license suspended freely, voluntarily today? Okay. In fact, you drove in Huron Township on June 1 and your license was suspended at that time. Is that correct? Satisfied, counsel?
Satisfied, Your Honor.
So am I. What should I consider before I sentence Mr. Carter?
Being quite busy at this time, nor be there are arrangements made for him not to have to drive on this occasion. He did not have transportation. He needed to clean clothes.
Yep.
Get to work. It was a situation in which he should have been driving, but he's not normally driving.
Okay.
He doesn't need to leave vehicle residence in New Boston with his mother and father, Your Honor.
Okay. Anything you want to add? All right. I'll stick to fines and costs. $500.
Thank you, Your Honor.
All right. Sir, that money's due today. You can go downstairs and talk options with the clerks.
Sorry, just a moment.
You're welcome. You can contact the probation officer about his daughter.
But she has my permission, she can call my daughter, or I can bring my.
That's probably not the way she's going to do it. She's probably going to want you to bring your daughter in for a conversation. But you contact her and she'll tell you how she wants to do it.
Yeah, it's not right there right now. Put it there.
Good. Where at? Okay.
And just like that, the tone shifts completely. What started as procedural decision-making now turns deeply personal. This is where courtroom reality hits hardest, because beyond the legal arguments, these are real lives, real struggles, and real consequences unfolding in real time.
How long they been doing this? Good. 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 Seen improvements? She's getting along with the therapist then. Good.
Yeah, her mother died in November, and then her stepmother died in 4 months after.
Oh, boy. So are you in grief counseling?
Trying to break these kids. I got a 4-year-old. I'm doing this on my own.
Get yourself in counseling. Seriously, it'll be a big help to you. It'll be a big help to you. Because you can't take care of the kids if you're not healthy. Healthy, right? You gotta, there's healthy ways to grieve and then there's unhealthy ways to grieve. So I would highly recommend you seek some counseling. And usually a lot of the local funeral parlors will hook you up with grief counselors, and it's free. So look into it and talk to her about it, Miss Oswald. All right?
Yes.
Yep. Good luck. I'll probably see you again with your daughter. All right.
This courtroom scene becomes highly charged as the defendant puts forward serious allegations against her own attorney. She asserts that her legal rights and personal privacy were infringed, and her emotional remarks intensify the situation quickly. As she continues speaking over the judge, the atmosphere in the courtroom grows increasingly tense. The judge intervenes decisively, aiming to restore order and ensure the proceedings remain properly conducted. Despite her repeated interruptions, the judge clearly emphasizes that established courtroom procedures must be respected at all times. This exchange underscores a clear tension between emotional expression and judicial authority. Ultimately, the judge's composed yet firm response brings a noticeable shift in the overall tone and control of the courtroom.